Loud little ducky and her ducklings always seeking justice and truth. This ducky won't be silenced by the haters, seeking out the facts while providing the receipts. She is loud with her opinions in this cruel world of villains. This ducky will talk, give her sass, while still keeping her class. So join in the pond with the ducklings from all over the place.
Of the Injunction Against Harassment in... I'm muted? How? Am I still muted? Okay. Okay. I don't know why it was muted. Everything else was unmuted. All right. So today we are going to go over the Injunction Against Harassment, the last little bit, which is closing arguments, because that was not in the video that we watched last, but Snitchel Ninja has the last bit of that. So we're going to go ahead, watch that, and maybe see some of Dingus's blogs. And then I'm going to go get a haircut because I'm so tired of this hair. And the hello, Texas Packet. Hello, Sherry. Hello, Bruce. All right, let's get this pulled up. Gives me a break from watching the financial stuff in the Corey Richards trial. That girl seems to get her money advice from Ron and Jan Owens. All right, here we go.
I just wanted to move, if now's the right time, move to admit the exhibits that we talked about so far, which I believe were plaintiffs 1 through 13. And I'm gonna, there's 4 other ones which are long videos.
Okay.
I was going to submit them. It's just part of the record. If they object,
I'll have to review them. So if they're hours,
I don't want to do that to you. I think we have enough. We have to prove 2 incidents. Okay. I don't want to prove 200.
Well, if you want to, I'm not saying anybody can't present additional evidence, but I would ask that you tell me where, in the document. So if you're not asking, then, so exhibits 1 through 13, you're asking for the admission of those.
Correct.
And then I know exhibit, is it 2? That was the exhibit that was something that she had created that you had concerns about, counsel?
I believe that's correct, Your Honor. And we would also like to renew the same objection to other exhibits that were clips that were put together outside of the correct context. Those would be
what's the correct context?
The full context of what my client said before and after.
Okay, but you can present that, right?
I can, Your Honor, but in the interest of time, I would rather just move things along.
Okay, so I'll leave out exhibit 2, but it sounded like, if I understood, that was information that she was testifying to anyway. So exhibits 1 and then 3 through 13 are admitted. I'm gonna rely on defense to put on that context or to explain the context, whether that's through playing videos or testimony. So those items are admitted. What else do we need to talk about before Ms. Owens steps down? And did you want to be heard further on exhibit number 2?
No, I don't think we need that. And
Okay.
I was going to read evidence rule 106, which I think Your Honor just completely complied with. If a party introduces all or part of a statement, an adverse party may require the introduction at that time of any other part of or statement that in fairness ought to be considered at the same time. And the adverse party is the one doing that. So as long as that's what the court did and intended to do, then I'm totally fine with that.
Yes, I will hear from defense in terms of the context, whether that's through presentation of parts of the videos or through testimony. You have the opportunity to explain.
And I don't believe, exhibit wise, I don't believe I've received any videos from them, so I don't know that they can introduce complete, but they have transcripts. And if Your Honor wants to look through that mess, I mean, that's up to you.
So we've watched this part, but it leads into the next part. But just to emphasize, the judge is telling the defense, if you want to add context through testimony or presentation, you can. That's how we're going to get the context for it, is by you doing this. And for some reason, they don't. And Gingras is like, oh, I don't want to give you those videos so you don't have to, I don't want to subject you to those videos. And, oh, I don't want you to have to read through the mess of the transcript, which I don't think the transcript would fully be helpful here. The video would. And then he's like, well, even if they do have video, they haven't submitted it to us, so they're not going to be able to use it. It's just so ill-prepared. And I don't know if Rob's the one who made the decisions and his lawyer was just like, okay, or if his lawyer was the driving force, but because there's no context and there are things that are somewhat on the line, and in the way they're said without any of that context, it can call for this injunction. It's just horribly done. But let's get back to it while Gingras is performing for his mother.
Okay. So, okay. All right. So maybe you can discuss it that way. The context you were just referencing. Okay. All right. So can Ms. Owens step down?
Yes, please.
Okay. You can step down, ma'am. Thank you, Your Honor. Welcome.
Can we maybe have a 5-minute break for everyone's comfort and so forth?
Sure. If anyone needs a bathroom break or to get a drink, we'll take a 5-minute recess and then we will restart with a defense case. You're no more witnesses, correct? Okay. And Mr. Andreev. I was close, maybe close. Okay. Okay. All right. Then you're calling Mr. Andreev?
Your Honor, in the interest of time, I would like to testimony here.
Oh, okay.
The closing statement.
Okay. All right.
No, not in the interest of time. Make her continue it. Just because you couldn't get through everything because Gingras took up most of the time, and then the amending the complaint and everything else, everything that was taken up was Gingras. You have to fight. You can't just leave this all out here unexplained. Horrible decision.
Then plaintiff will start.
Well, okay, yeah, I guess that's fine. Do you want me to argue from here or from here?
Either way, as long as
Microphone's
as long as you have a microphone, either place is fine.
Microphone's better here. Your Honor, this is first of all, I'm a lawyer in a number of ways, but I definitely consider myself to be a First Amendment lawyer. I've litigated tons and tons of First Amendment cases, usually on the defense side. Very rarely am I on the plaintiff side. And I love the First Amendment probably as much as,
I'm only on the plaintiff's side because it's Laura. Otherwise, I'd be on the defense's side.
Being a lawyer. I really was proud of Laura for explaining to the court that she does not object to people talking about her case. She couldn't take that position. I wouldn't support that position. The First Amendment allows.
Sorry to keep pausing a bit. No, you have let her make that argument before. You have supported her in making that argument before of people saying things. You've tried to shut everybody down because they are talking about her and you in this case. So you're just lying to the judge now.
People to speak, especially when there's matters of public interest and concern. A criminal case is a matter of public interest and concern. People can talk about the case. There's no objection from our side to that. What you saw from the evidence was not Mr. Andreev talking about the case. He was talking about Laura in a sexual, violent.
Sure, if you take what? I'll say max 5 minutes. 5 minutes out of multiple hours. Even if it was all in one video, 5 minutes out of a 2 to 3 hour video. Yeah, it's going to sound like he's not talking about the case. But if you watch the whole thing, you will see he's talking about the case. And it is sadly true, Bruce, that douche canoe and pregnancy faker walked all over Rob's lawyer. And he's doing a good job. It's just the bullshit that he spews out of his mouth, we know is fake. If we didn't know him, maybe we could believe him. But we know this isn't true because he's shown he does not believe what he's saying right now.
Disgusting manner that has absolutely no value under the First Amendment because, Your Honor, there is conflict. As much as the First Amendment protects the right to speak, people have the right to live their lives in peace and free from harassment and threats. And I think Laura put it best when she said that she really tried to not pay attention to the defendant until he went too far. And that comment about inviting people to, hey, let's make a phone call and pretend to be L-O, Laura Owens, that was scary to her. And it absolutely was appropriate for her to be scared. And I was thinking about how I could explain this. I think you're getting it, so I don't need to go too far with this, but I'm going to just hypothetically pretend that somebody didn't like a ruling that you made, and they made a YouTube video saying, hey, the judge has some kids and here are their names, and why don't we call up every school and see where they go to school and pretend that would, if somebody did that, to Your Honor.
This is not that. That is completely separate. That's trying to get to children. And the schools shouldn't be giving that information out, whether somebody was impersonating somebody or not. And usually in arguments to the court, like if he was in front of a jury, he would not be allowed to say, hey, jury, picture if this was somebody going after one of your kids' schools. He would not be allowed to make that argument. They are not allowed to do like hypotheticals, put yourself in this person's shoes. They're not allowed to make those type of arguments. So the fact that he's making one to a judge, I don't like. It's hyperbolic.
They would be in jail immediately and belong there. And if they tried to use the First Amendment as a defense, good luck. I know the First Amendment extremely well. Threats, harassment are not part of the First Amendment. And what you saw and the impact that you saw on Laura, having to sit through that and watch that. And it's an interesting argument as far as the LaFaro versus Cahill case, which is it's cited in the pleadings, and it's an important enough case I wanted to briefly mention it. That case involved a verbal statement made in public in the year 2000, so 26 years ago, between two political candidates for Tempe mayor. And one of them was standing out in front of the library in Tempe, and they made some comment that the other side didn't like, that led to a harassment injunction proceeding. And the court said, nah, that's, you know, a verbal statement made to a crowd is ethereal. It drifts in the wind and it goes away. That's not directing contact with or directing conduct at a person as required by the harassment statute. I've cited, for your honor, 2, maybe 3 cases. There are 2 unpublished ones and there's a published one. I think it's Snyder, Williams, and Raber, which is in our pleadings. Those are recent cases with completely different facts involving this type of social media harassment. And the law is crystal clear.
I've broken down why Snyder doesn't apply here. And the judge broke down why LaFaro doesn't apply. So all of Gingriss's sightings are bullshit and stupid and not relevant. Once again, he never connects cases that are actually relevant to things. That's why in the bankruptcy case, when he's saying that what Jennifer Guillermo is saying in her filings, he's like, the statute says what exactly the opposite of what she's saying it says. I don't know. I can't believe that, because you're the one that's always wrong on sightings. If he happens to be right, I'll be like, okay, clock's right twice a day. So I guess he can cite at least one case, but we'll see how that goes. But right now, his cites are not on par.
It does not matter that the defendant didn't send anything directly to Ms. Owens. If she found out about it through any means, it's still there. He took some of the things down, and that's nice. I appreciate that. But having these things online, social media, is an entirely different animal. It is categorically different than words spoken to a crowd. And I know because Mr. Andreev has done the same thing to me. We haven't even brought that up. But he's posted videos about me, and you saw in one of that scary voice one, there's some sort of an art thing which shows me and Laura standing next to each other. I've represented her for a couple of years, and so people that don't like her, by extension, don't like me. That's okay. I don't have a problem with that.
No, David. That is I gotta sneeze. Oh my gosh. Okay. No, David. No. It is not by extension that because we don't like Laura, we don't like you. That is not true. We don't like you because of you. We had no problem with any of our other attorneys. None of them. You and the way you behave and the things that you say is why we don't like you. It has nothing to do with the fact that you are the lawyer of somebody we don't like. Because guess what? We don't say anything about Laura's criminal attorneys, the 2 that she's had so far. Notice we don't say anything about them. So it has nothing to do with the fact that you're Owens' attorney. And Bruce saying the main thing that Rob's lawyer needs to do was explain to the judge how the live streams in full context are information and entertainment at the same time and therefore not valueless. Yeah, context, which was never given. And Gingras has gone on public platforms and claimed that he started the case threatening people. He still threatens people. His newest blog post to me, well, Omar is probably not scared of it, but sounds very threatening. Gingriss's newest blog to Omar sounds very threatening. But Omar's not a pussy.
No, what's scary about this sort of thing is these statements are online forever. They're around the world. And unlike talking to a crowd at the Tempe Public Library and you say a word and the crowd disperses and it's over, these things are online forever, and Laura doesn't know who's seeing them. She doesn't, all it takes is one lunatic. I mean, you look at the environment, the climate these days with like Charlie Kirk being shot in the neck in Utah. And I posted a video a while ago. I used to put things on YouTube. I don't anymore. But the governor of Utah came forward and did this interview with 60 Minutes. And he did such a good job explaining that, social media attacks, it is a First Amendment thing to a point. And then it becomes too much. And it becomes scary. And in that case with Charlie Kirk, he sort of was a very high level public figure. And he said some things, somebody didn't like it, and they killed him. And
seriously, Gingras, you have to go political every single time. This is not a political debate. There's nothing political about it. You know why? Because there's no division. This is something that the world could all come together on. Laura Owens brings unity in our country. Something politics doesn't do. But he's got to bring it up.
The governor of Utah was making this impassioned plea on 60 Minutes to turn the temperature down, stop harassing people and threatening people and riling people up. And I think, again, Laura's going through an extremely difficult time in her life dealing with a criminal case. Anybody would be having a hard time with that. And she understands the criticism as part of that. She doesn't object to that. But talking about having her be raped in prison, having Mr. Andreev say that he wants to sit on a plane next to her and join the Mile High Club. Well, I will tell you that before I did my brief in this case, I went and read I went on Westlaw and I got the Injunction Against Harassment statute. I read every single case, every single annotated case I read. I did not find a single case that was as offensive as what I've heard in this case, or as scary. People have been sent to prison for much, much less than what we've heard today. And so I love the First Amendment. I respect the First Amendment. When you get this dirty, you lose the First Amendment rights at some level. It's sort of like a Second Amendment thing. You have a right to have a gun. Mentally ill people aren't allowed that right. Mentally ill people can't have a gun at all. And based on what I've heard, I don't see any problem with the court restricting Mr. Andreev in the way that.
So are you calling Rob mentally ill here? Like, seriously? And oh my God, it's just, I lost what I was going to say because, oh, I know what it is. The whole getting on the plane, he said that was like as crazy as, or it would be like if I got on a plane with her and this happened. It was a situation where like it would be funny if we ended up on the same place going to California. Like that was it. What if I got on a plane and I don't know, Scarlett Johansson was on the same plane as me? No, I'm not going to try to get her to join the Mile High Club, although that would be legendary. It's just so out there. It's just so out there, especially knowing the shit that you've said to people.
It already has. So you should affirm the order. I would actually ask that you expand it. I would want an additional proximity limit where he's not allowed to come within 500 feet of her. I would actually ask the court to make that specifically include court hearings. I found out yesterday, unbeknownst to me, in her criminal case, Laura's criminal defense lawyer filed a request for her to appear virtually at a case management conference coming up because of Mr. Andreev, because he's attended every hearing. And we're dealing with this scary content that he's put out there. So Laura's explained to the court she doesn't even feel safe coming to court because of him. That's unacceptable. That is totally unacceptable. So I would ask the court to.
It is not unacceptable to go to a court case that she is at. It's not at all. I know others that have probably been to most of her court hearings as well. And you know what the judge said about her appearing virtually because of this? Too damn bad, show up in person.
To affirm the order and add a proximity restriction that includes he can't go to court hearings. He can watch them virtually. He can read a transcript. He can watch it on YouTube. He should not come to court and scare her anymore. Obviously, we're asking for fees. It's obviously in the court's discretion. I don't believe we should have even had to come down here today. There's no dispute that these comments were made. He submitted paperwork to the court that accused Laura of fabricating. And I understand there was a bad adverse ruling, which we are dealing with, and I don't agree with. I understand judges make rulings, and I respect them always, but I don't always agree with them. There was an adverse finding about her doing some things in the other case. She hasn't done anything in this case but tell the truth. And he hasn't even challenged a word that she said as far as what he's accused of doing. So we shouldn't have had to come down here. He should have to pay for that time. So I'd ask for the award of fees. Your Honor, I also made a request for a criminal referral. That's up to you. I understand as far as I explained and I accused Mr. Andreev of perjury. I think what he did was perjury. I understand, and there's a case called Braunston versus the United States. It's a U.S. Supreme Court case that deals with you can't be charged in federal court with perjury if you said something that's literally true, but it's really misleading. I get what their argument was, that he was denying making a statement in video 272, but actually he knew that it was 273. That's up to.
He probably doesn't remember what he said in any of his other videos. He probably doesn't remember it was 273. With as many videos as you said he's made, he's supposed to remember that one statement out of there? No, that's not how the law works, Gingras. Nobody's getting referred for criminal prosecution. I don't think you deserve fees because you accepted this pro bono, which means I don't think you should be paid. You want payment? Get Laura to pay you. And Gingras is right. Rob and them have not challenged anything that Owens has said in court today. So Gingras gets to stand up there and make that argument that he didn't come up here and deny any of this. Gingras shouldn't have been able to make that argument. But that's what happened here.
The court, if you want to make a criminal referral, I just want this to stop. We should not have to deal with this. And the fact that we're even talking about this, it's just inappropriate. So affirm the order, expand it, award fees, and do what you want with the criminal thing. And if you have any questions about the legal side, I've cited the case law for you. There's no argument from their side that harassment is protected speech. It's not. Because harassment is a different thing. When you terrify somebody, when you do what the type of things that we've seen here, that's just outside the First Amendment. So there's not a legal issue in that regard.
All right, thank you. And from defense?
Thank you, Your Honor. This case is not at all the open and shut case of harassment that plaintiff and her counsel would have you believe. This is about a defendant in a high-profile criminal case trying to silence an online critic. You heard her counsel ask for an order that would prohibit Mr. Andreev from exercising his First Amendment protected right to attend public proceedings in a criminal case. You heard her testify that he has never, ever communicated directly with her. The only thing that he might have said to her is maybe hello when they passed each other in the context of a court hearing. He hasn't been intimidating her via appearing at court hearings. You know, counsel says vigorously in his papers as well that the First Amendment does not protect harassment. Of course it doesn't. We don't argue with that. But what you have here is not harassment. As we've shown in our papers, Ms. Owens cannot prove, and she has not met her burden of proof here, to prove 3 out of 4 of the essential elements of harassment. Mr. Andreev's comments were not directed at her. Mr. Andreev's commentary about her court cases has a legitimate purpose because it is fully protected by the First Amendment as speech about issues of public concern. And none of the comments Ms. Owens identified or presented to the court today would cause a reasonable person to feel harassed or threatened. If we're able to have injunctions against harassment because somebody said mean things about somebody else on the internet, we'd have to have injunctions against half the people against the other half of the people. It is not against the First Amendment and is not against the law to say mean things about someone on the internet. It's not against the law. It's not harassment to use crude and vulgar language about somebody else. Certainly, Mr. Andreev has strong opinions about Ms. Owens, including that she has misused the courts to unjustly persecute her perceived enemies. You heard that in Exhibit 5. And, unfortunately, Your Honor, she's doing it again. She's doing it to him. He criticized her for what he believes is her misuse of the court system. Now she's doing it against him. As Your Honor knows, the elements of harassment under ARS 12-1809T are that it is 1, directed at a specific person, 2, that it would cause a reasonable person to be seriously alarmed, annoyed, or harassed, 3, that it actually caused the victims to be seriously alarmed, annoyed, or harassed, and 4, serve no legitimate purpose. Taking the 4th element first, and notably in his presentation, Mr. Gingrich didn't mention that particular element. But as we explained in our papers, Mr. Andreev's speech here is commentary about issues of public concern that has the highest protection under the First Amendment. The U.S. Supreme Court held in Snyder versus Phelps that vulgar speech, speech that causes emotional distress, speech that is really reprehensible, cannot be punished if it is speech about an issue of public concern that is not otherwise a true threat or true harassment. Mr. Andreev's speech serves a legitimate purpose, so it's not harassment as a matter of law. To the first element, Mr. Andreev's commentary is not.
The only thing here is he would be able to probably make this argument if there was context. But since there's no context and all we have is like the 5 minute of verbiage from Rob, those things that are said in the 5 minutes don't necessarily have a legitimate purpose. The legitimate purpose that goes with all those is the 2 to 3 hours in each video, probably 6 hours, 5 to 6 hours. If you combine probably both of those videos, they're getting that out of. So 5 minutes that you have out of 6 hours possibly. And so while great, Rob's attorney is arguing that, the judge doesn't have any context to be like, you're right. The rest of this stuff that's just this little snippet that's taken out of has a legitimate purpose. But it's cherry picked. And Rob and his attorney let him do it. And I'm not saying it's Rob's fault. I'm not saying it's the attorney's fault. I don't know who made the decision. But he's arguing something that there's no proof of right now to the judge.
Not directed at Ms. Owens. He posted on the YouTube for the world to see. He has not communicated it directly to Ms. Owens. She had to go out looking for it. He didn't direct it to her. She had to go look for it. It's about her, sure, but it's not directed at her. And let's talk about the case law that plaintiff's counsel has cited. LaFaro, I don't read LaFaro as saying that speech to a crowd isn't harassment because it's ephemeral. The holding in LaFaro was that when someone makes a comment to another person or a crowd of persons that the plaintiff simply happens to overhear, that is not directed at the plaintiff, and therefore it does not qualify as harassment. Now, the three cases that counsel cited in his briefing, the one presidential case and the two non-presidential ones, they all involve cases where the defendant actually did direct speech towards the victims in those cases. In the one presidential case, I apologize, I can't remember the name off the top of my head, but it involved two people who were divorced spouses who both had worked at APS. The ex-wife contacted the ex-husband's co-workers at APS, saying bad things about her ex-husband, urging them to contact her, urging them to knock some sense into him. That is obviously speech that is directed at that person because they were directly contacting people in his life, his coworkers. One of the non-presidential cases, I believe it was the Snyder case, the defendant in that case also directed social media statements about the victim to her coworkers, to her clients, to her former employer. That defendant actually recorded a video of himself outside of the victim's place of employment and sent it to her clients and former coworkers. Obviously, that's directed at the victim. That's not what Mr. Andreev did here. In the Williams case, the other case that he cites, that was a case where a photographer apparently became obsessed with a model. In that case, the comments that the defendant in that case made were tagged directly to the victim. In other words, the defendant in that case sent his comments, some of them, directly to the victim. That's not what we have in this case. And, Your Honor, the requirements that the speech be directed at the plaintiff and that it have no legitimate purpose, they serve the purpose of protecting First Amendment speech. The Supreme Court has been very clear that the First Amendment protects a robust and vibrant and sometimes difficult and emotionally hurtful national debate. But we have to give that breathing room for that kind of rollicking and at times unpleasant, at times vulgar kind of speech, so we can have the kind of robust and wide open national debate that the First Amendment is designed to protect. And that's what's at issue here, Your Honor.
I'm going to back up and I'm going to take the captions off. I'm going to make this a little bit bigger. Watch what Laura and Gingras are doing. Just writing notes back to each other, smiling and just kind of like giggling a little bit. Let's take these captions off. Let's go back just a bit. All right.
Her clients and former coworkers. Obviously, that's directed at the victim. That's not what Mr. Andreev did here. In the Williams case, the other case that he cites, that was a case where a photographer apparently became obsessed with a model. In that case, the comments that the defendant in that case made were tagged directly to the victim. In other words, the defendant in that case sent his comments, some of them, directly to the victim. That's not what we have in this case. And, Your Honor, the requirements that the speech be directed at the plaintiff and that it have no legitimate purpose, they serve the purpose of protecting First Amendment speech. The Supreme Court has been very clear that the First Amendment protects a robust and vibrant and sometimes difficult and emotionally hurtful national debate. But we have to give that breathing room for that kind of rollicking and at times unpleasant, at times vulgar kind of speech, so we can have the kind of robust and wide open national debate that the First Amendment is designed
It's right
to
here.
protect. And that's what's at issue here, Your Honor. Going to the second element, Ms. Owens has not met her burden of proof to show that the speech would cause a reasonable person to feel harassed. Yes, he used vulgar language. Yes, he expressed the opinion that she's guilty and should go to prison. Yes, he expressed his view that she's misled multiple courts. But no reasonable person would consider that to be harassment. And as plaintiff's counsel said, in response.
Objection. We're not dealing with a reasonable person. Objection. No reasonable persons are in the room.
Mr. Andreev's motion to quash, Ms. Owens went nuclear. Her response brief falsely accuses Mr. Andreev of committing multiple felonies, including perjury and felony harassment. It's just not true, and it's not true based on what is the content of the reply brief, of the response brief itself. She accuses him of violating the injunction, likening it to one of those cases in which a defendant posted online a image of the protective order in that case that included the victim's address. Here, as Ms. Owens testified, what he posted online didn't include her address. The injunction did not prevent him from talking about the injunction. The injunction, despite what she may believe, did not prevent him from talking about Ms. Owens. And he didn't violate the injunction in any manner whatsoever. And she also accuses my client of perjury for what he said in his original declaration. And as you saw, Your Honor, what he said in his original declaration is absolutely 100% true. The statements she attributes to video 272 do not appear anywhere in the transcript of video 272. That's what he said in his declaration, and that is absolutely true. And it is, quite frankly, offensive that she would accuse him of perjury, of a crime, of deliberately lying to this court, when what he said was precisely, absolutely true. It is her burden of proof here. If she makes a mistake in her petition, she can certainly correct it. He made a mistake in his original declaration. He corrected it.
Attorney Kelly, is it? Laura doesn't understand perjury. I'm not sure her attorney does either, the way he argues it. But she thinks that things are just minor. If you just minorly lie, which her minor lies are major lies, not like little white lies. So yeah, she's going to accuse people of perjury because she's accused of perjury and she doesn't get the concept for some reason. Even though she's charged with it a bunch of times and many lawyers should have explained it to her by now.
In candor to this court. He didn't have to, but he did because he wanted to make sure that the court had the facts. In sum, Ms. Owens' petition is baseless. It's meant to try to shut up a critic who makes public statements about the issue of public concern being her court cases. And, Your Honor, we would ask that you award us our attorney's fees and take into account the false accusations against my clients of felony conduct. Thank you.
Anything further?
In about two minutes or less. And Your Honor, thank you so much for giving us more time. I really appreciate it. Very, very briefly,
Your Honor, let me just kiss your ass one last time before you make this decision.
couple legal things and a couple factual things. Legally, all the court has to do is read the Snyder and Williams and Raber cases I've cited in my pleadings. Those cases tell you everything you need to know about the law. Yes, two of them are unpublished, non-precedential. They're still, you can still look at them and consider them and follow them if you want to. You cannot ignore Raber. It's a controlling published authority. Those cases involve conduct that is so much less worse than what we heard today. So much
less worst. That doesn't even make sense, Gingras. Also, it doesn't matter about how worse the words were or not. It matters if things were directed at her, if he was contacting her, and he hasn't. The difference is in your cases that you cite, in this case, are direct contact, third-party contact, which has not happened in this case. So it doesn't matter how minimal the words were. You can exchange them for any words in the English language. If there was no direct contact, third-party contact, going to have interactions with people, it doesn't matter. The case doesn't fit this. Your argument is invalid.
much less. And let's talk briefly about what you heard today. What we heard was almost nothing about Ms. Owens' criminal case, almost nothing. There was I didn't hear Mr. Andreev say a word about what she's charged with or why there's some significance to that fact. He talked about her body. He talked about wanting to join the Mile High Club.
No, in that 5 minutes that you've shown out of the 5 to 6 hours, no, there wasn't anything in those clips that you played. Could Rob have played those to show that there was? Yes. You also objected to people asking her about things pertaining to the criminal case, which also means you can't talk about, she couldn't talk about the paternity case because that's where the criminal case comes from. But this is why he needed to put on a defense. Because Gingras wouldn't be able to make these arguments if they had put one on.
The paternity case until when I was seen in court. And so like the anorexia was.
My bad. Let me see here.
Against to that fact, he talked about her body. He talked about wanting to join the Mile High Club with her. He talked about her performing oral sex on prison guards and getting pregnant in prison. I didn't hear a matter of public concern insofar as they're arguing the criminal case is a matter of public. That's all correct. That's not what we're here to talk about. We curated these exhibits very carefully to not focus on First Amendment protected speech. If he wants to talk about her criminal case, great. Stop calling her a cunt and a whore and making statements that are inflammatory. And the reason, Your Honor, that I think you really should expand.
But what if she is a cunt and a whore? Those are people's opinions. People can call her that if they want to. They can call her a bitch. It's not against the law to say that.
And the order to say he is not allowed to attend any more court hearings. Ms. Owens has a right to sit in court not in fear. And if she was sitting on the witness stand today, she had to look at this man who she knows what he has said about her and how horrible of a person he has acted like. And she shouldn't have to deal with that in addition to everything else she's going through. He's posted pictures of her house, not within the last year, but I showed that as just a part of the intimidation that he has committed against her. And as far as this issue of
Rob's attorney should correct this. They didn't. He showed that. Now he's saying it's part of the intimidation. No, it's not, because everybody knows what it looks like. It's public record. And it's been put out there. He didn't go seek that information. We were all given that information. So it's just bullshit coming out of his mouth. And arguments that he knows are lies. He doxes people's address. That's intimidating. I don't want them doing things to people's houses. But rules for thee, not for me. Gingras' motto.
Me going too far with accusing him of perjury. Your Honor, you're the fact finder. You can read his declaration, the first one that he filed, and couple that with his pleading that he filed at the same time. His declaration said that he quoted these things that I'll fucking bitch slap her through the phone and she's a fucking twat, she's a hole, she's a cunt. And then he said that statement appears nowhere in that transcript or in any other live stream Owens cites for that matter. And then in his pleading, he says, contrary to Owens' mischaracterizations and outright fabrications of what Andreev actually said. If I were you and I read those things, I would say, she must have lied. She lied. He never said these things. They're fabrications according to them in a sworn statement under penalty of perjury. He knew that he said those things. You heard him say those things. He didn't take the stand and deny that he said those things. Was there a typo on which thing? Yes, there was a typo, but he doesn't say that. He says that those statements do not appear in any other live stream she cites, and she cited them all. She brought to the court's attention that there were 1,400 of them. And I'm sorry that she made that typo, and I'm sorry that she didn't have time to go through every single video. But to me, when I read that, there was a clear intent to mislead the court about what was happening in the factual realm, that he tried to convince you that these things never happened, and they did. We just watched them all. So that, I think that's perjury. Whether you think it's perjury, that's your call. But that's certainly enough to warrant, first of all, upholding the order and expanding it and awarding us fees, because we shouldn't have had to come down here to do any of this. So that's all I have to say, unless you have questions.
I don't think I do have questions. All right, so like we discussed earlier, this was a lot of information to try to take in and to do quickly, and some of that I only received today, not due to anyone's fault, just the shortened time frame here. So I'm going to take this under advisement so that I can review the motion to quash, response, and reply, and then I will issue a ruling at that time. I will try to get it done today. So I don't in any way want to belabor this issue for you all. I just want to make sure that I have been able to thoroughly review everything that was submitted in writing in concert with the arguments that both sides have made here today. So having said that, do we have to distribute something immediately so we can send it after? Okay. Okay. So having said all of that, is there anything else we need to discuss for today?
The only thing I would add, Your Honor, is in my effort to be a helpful counselor, is if, as you're preparing all this and researching, if you have any questions, if the court wants any kind of supplemental briefing on a legal issue or anything like that, please feel free to ask. I try to be helpful. So I don't want you to feel like there's a question you're not sure about or whatever.
Sure, sure.
Yeah, and the same goes for.
Okay. All right, I have only been in this assignment since October, so I'm not shy about asking for briefing. I think I'm going to be okay on this one, but I will keep that in mind if I decide that's not the case, and I will let you all know so that you can address any concerns, okay?
Thank you, Your Honor.
All right, thank you. We're adjourned. Have a good rest of your day, good weekend.
Thank you.
And we will send it out by email. So I'll get it out to you all as soon as possible. Like I said, I'm hoping for today. Today's normally a day that I have opportunity to get paperwork done. So hopefully this can be one of those things.
Have a nice weekend.
Thank you.
See them get out of court. If that's Chingras's mother, she did not sit next to the Owens, so I don't know how she feels about the Owens. Rob kind of looks defeated sitting there. But which with the ruling, I could see that, but Gingras. All right. So I try to be helpful, Your Honor. I'm just a happy helper. Oh, Lord. And I think that's why she probably got put on this case, is because she doesn't know. They maybe should have put a judge on that did, but Gingras probably would have objected to all those other judges and so forth. So let's bring, okay, if any of y'all watched Omar's breakdown of this and his thoughts and things like that last night, if you haven't, go watch it. It's great. Reaffirms, made me feel better about things that I was saying. And that other people have pretty much said too, is this just needed to be fought, and it wasn't. All right, we're going to share this tab. All right. Don't worry, Tex. I do voice to text a lot of times, and it sounds awful. No. All right. So this is his latest blog post after he, I guess, listened to Omar. Also, don't forget to like, comment, subscribe, all that stuff. Hello, replay crew. But Gingras labeled this as pearls before swine with a pig emoji. So he says, I have a lot of flaws. One flaw, I feel a burning need to correct misinformation when I see it. It's pathological. At least it's just not me. The thing is, you put out a lot of misinformation as well. So that seems odd. Then he has this little cartoon. Are you coming to bed? And it's Gingras, I guess. I can't. This is important. And somebody says, what? Someone is wrong on the internet. Yeah, okay. So he said, I saw this thing about Omar and fees, and I was triggered for the 347th billionth time. And he puts up a comment that says, Omar will be filing for attorney's fees this week. And it says, David, you have to help them understand. So she calls him, David, I need your help. They're going to try to get me to pay money that I don't have once again. I need you to come to my rescue, basically. He says, then he realized something. No, I don't. You're exactly right, Jingris. No, you don't have to help anybody understand, because you're not going to help anybody understand your client. Nobody understands Laura's mindset and where she's coming from on things that she's done. A therapist is the only person that can help her, and it's not going to help figure out certain things. It's going to help her be able to cope and deal with things better so that she doesn't act like this. Because we can understand how people get to and do certain things. I can understand somebody living a double life and then offs one part of it so that he can have this other part, like Corey Richards, for instance, right now. Allegedly poisoned her husband, wanted to take off with his money because her financial situation was so bad, and live a happy life with her paramour. While I can understand Corey Richards' thinking, that does not mean it doesn't deserve consequences. Understanding doesn't equal it all goes away or make it right. But Jingers goes on to say, JFC already thinks I'm an idiot. Nothing I can say to them will ever change that. No, you could change your behavior, but you don't. You say you're going to, and then you don't. The line that fits, pearls before swine. So for once, just this once, I shall reject the impulse and just leave this one alone. I won't explain, I won't guide, except for in the background, you will. You're just not going to do it for her necessarily fully. I'll just sit back and wait for the boot to enter the bear trap. No need to say more. You'll get it. Pig emoji. That kind of sounds a little bit threatening for Omar, right? What do you mean boot enters the boot trap? Like the fees and awards and all that stuff that's going to come out of this next chapter of the Mike Maricini versus Owens stuff is going to what? It's not going to show Laura's in the right. It's just not. So we'll really see who ends up in this pigsty and whatnot. The casita is a pigsty. I need to clean up my pigsty. But what are you waiting for the next shoe to drop? Because it's not Omar's shoe. Laura's going to lose both of her shoes. Because she's not Cinderella. So she has to lose both, not just one. So, yeah, that's not threatening language or anything. Then this is what he says about Love Trapped. Episode 1. On my daily walk this morning, I listened to Love Trap Episode 1. The theme music was interesting. The number and length of ads was super annoying. I do have to say, it's the same ads over and over again, at least for me. I don't like that. But I think I can skip past them. I think I was able to skip past some of them. Love the theme song. All right. So he says, content-wise, I thought the episode focused way too much on not just Clayton, but The Bachelor in general. Yes, I know the background stuff is for context, but I got seriously bored in the middle. Okay. You have um to understand what's happening now, you have to go back to the beginning. You have to understand what all Clayton was dealing with to where his mindset and the reason for things that he was doing. Stephanie has said she would love to hear Laura's side of it. If we need to go back to the beginning to understand what's going on with her now. And I think Stephanie explained it very well, in my opinion, about her feeling like kind of the black sheep, that she wasn't good enough because she didn't have the career and stuff like her parents, but she also didn't have a partner and children. So both things that she seen are successful in her mind, she doesn't have either one of them. She thinks of herself as being all alone. She doesn't love herself. And so since she doesn't feel like she has anybody to love, including herself, she puts her love into her animals. And so I think the context of who they are as a person before we got here is important, even if you don't like it. Jinger says, I didn't watch Clayton's season, and I don't care if he's the most popular bachelor or the least. But again, I understand why context was arguably needed. Okay, then why did you even put this paragraph in? Clayton's discussion about having a gun and thinking of offing himself, that felt performative, kind of too dramatic. I didn't like that. Well, what about your client? You don't think that's dramatic for her to be doing all that? Writing the FBI? Like, what? Oh, you don't think going to the Sun with this story was a bit dramatic? Filing an abortion coercion, something that doesn't exist in like a relationship form, isn't a bit dramatic? 3 people standing on Instagram. 2 people saying nothing and calling the cops on them. That's not a bit dramatic? A bit performative on Laura's part? Shut the fuck up. Plain and simple. Shut the fuck up, Jingers. Look, I had several long conversations with Stephanie Young over the last year. I found her to be professional, smart, and I believe she cared about telling the story the right way, meaning giving accurate facts and details from both sides. Over the years, I've dealt with tons of real journalists, i.e., not crazy people with a webcam posting garbage on YouTube. Stephanie is a real journalist. Okay, so what if we got jobs as a real journalist with a company, but we still had a YouTube? It doesn't make us any less of a journalist. But Stephanie is a journalist or a professional podcaster or whatever she is. But he continues on saying she made it clear she wanted to include Laura's side. She asked to either interview Laura or have me answer questions on Laura's behalf. Unfortunately, due to the pending Rachel Mitchell thing, that just wasn't an option. So with only one party able to participate, I'm prepared for Love Trap to be a lot more one-sided than it should be. Yeah, the criminal case. And maybe season 2 can be Laura's side of the story if she wants to talk after. But she's had time to tell her story as well. And Laura's story is out there through her legal filings of hers, her affidavits, her Medium articles, her videos she's posted, y'all's videos that y'all have posted together. So it's not one-sided. You keep thinking it's one-sided, but it's not. Owens has said a lot of shit. Anyway, the point of this post isn't to talk about the podcast. Then why did you name the title? A review of Love Trapped, episode 1. It's to share something I realized while listening to Clayton talk about his real estate career. I had no clue he had never done any deals before Laura. You didn't bother getting to know. This detail got me thinking about something important, which could be a big issue for Clayton in the bankruptcy case. Here's the deal. Clayton, with Woodnick, filed an adversary proceeding against Laura. Woodnick says $200K in fees should be exempt from discharge because it represents a willful and malicious harm suffered by Clayton. Yeah, if she maliciously lied, it should. If she lied about being pregnant and knew she wasn't pregnant, that is willful and malicious. All right. Yeah, we can see that. Owens' conduct did, in fact, cause significant financial harm to Eckerd. Yes, it did, because he had to hire lawyers like Woodnick, Isabella, Deandra. Yeah. He also has to take off work for this shit. See paragraph 35? It claims Laura caused significant financial harm to Eckerd. It doesn't explain precisely what that means, but it's not hard to guess. It's referring to the $200K in fees awarded to Clayton. That would be harm, although I would still argue it's self-inflicted harm, but that's a separate issue. It's not self-inflicted because he didn't get anybody pregnant, Gingras. Can't get pregnant off the blowjobs. I don't care what Dr. Medchill and his Virgin Mary say. He says, I have a theory about this. I don't believe that $200K debt is real. What? It's as real as the paper that they were printed on. The judges said that they were real. So, okay, I guess if a judge puts down that you owe somebody on paper, it's not real. It's not a real debt. Sure, the courts granted judgments in favor of Clayton, so the debt is real in that sense. Oh, okay. All right. What? But debts can be and often are forgiven, except for when they are done with malice. Or just waived in their entirety. So just because you incurred a debt on paper does not mean you have actually been harmed in the real world. Yes, because if she doesn't pay the attorney fees, he will have to pay the attorney fees. That is harm to his financial situation. Let me see here. I don't know. Okay. All right. Yep, he's called a bunch of people stopping him from making money as well. That is true. But none of that's real. None of it's real. Only Laura's delusions are real. He says, here's the thing. Clayton is only harmed by those debts if Woodnick actually forces him to pay that money. If the debt is waived / forgiven, Clayton never pays Woodnick. In that scenario, Laura did not, in fact, cause significant financial harm to Eckerd. There's no proof that Woodnick has waived his fees for Clayton. Just because you waived your fees for Laura for whatever reason doesn't mean that Woodnick did. Okay, I don't know who you are, Bethul, whatever. But no. Let's see. Okay. That person is gone. Don't know who they are, but okay. All right. Yeah, attempted to get fees. Yeah, he could just waive his fees for the injunction against harassment, which he said he was going to do anyways. Yeah, I just removed them. It was fine for the first minute, and then he got to other things. So I removed them and hid them. All right. So okay. Think about this. What if Woodnick said to Clayton, look, bro, don't worry about the fees. I won't make you actually pay any of this. I just hate Laura so much. I'm going to do the work for free and I will get the money from her. But if I can't collect from her, don't worry. You won't have to pay up. If you have proof that that has happened, okay. You don't have any proof of that. That's just what you said to Laura for the Rob thing. Look, sweetie, don't worry about the fees. I won't actually make you pay any of this. I just hate Rob so much, I'm going to do this work for free. And I will try to get the money from Rob. But if I can't collect from him, don't worry. You won't have to pay, sweetie. See how that works? These are conversations that you have with Laura. You're projecting. He says, really think about this for a second. Clayton is 32 years old. I don't have a lot of specific info about his current income, but I do believe he is rich. Do you really think a young guy in his position would agree to be legally bound to pay $200,000 in legal fees? Yeah. Rich people have to pay attorneys. So if you think Clayton's rich, why would Woodnick? If Clayton was rich, why would Woodnick forego his attorney's fees? If Clayton was rich, would you put yourself in that position, signing a contract to pay $200,000 that you knew you could never afford to pay? That's with a lot of different things. I don't believe that for a second. Okay. Even if he signed a contract to pay $200K, even if he could, let's say he is rich, okay? And he can afford to pay the $200K. That's still a financial hit because he's not like A-list celebrity famous. He's just he was a reality star. That's it. They don't make that much money. And his season has been over. He has to work a regular job now. That's what happens. And keep something else in mind. Before I started my own practice, I spent almost 10 years working at law firms in Phoenix. During that time, I saw clients rack up large bills they couldn't pay. In and around 99% of the cases, after the bill got above a certain level, the firm would fire the client and sue them for unpaid fees. I personally did this for my bosses, which sucked. No, you like doing that stuff. Lawyers want to get paid. If a client owes the money, the lawyer will pursue the debt. I've seen it. I've done it. That was pretty much the default situation in every real case. Okay. So this isn't a real case anymore. All right. This is just my speculative opinion, just like everything else you say. But I don't believe for 1 second that Clayton actually agreed to pay $200K to Woodnick. No chance. Yes, there's a written fee agreement that says this, but my belief is Woodnick made a second verbal side agreement with Clayton. He doesn't have to pay the debt if Laura can't or won't pay. Well, you don't have any proof of that, so it doesn't really matter. This is all public record, so I could share links. As a courtesy, I won't. Well, you should, but what matters is this. Records show he paid $739,000 to buy the house. Like most folks, Clayton needed a mortgage for the purchase. Public record shows he borrowed $665,910. So basically, he put 10% down and borrowed the other 90%. Okay. Why does this matter? Because when you apply for a mortgage, you have to give the bank tons of information regarding your income and your debts. There's something called a debt to income ratio, which is critical to anyone who wants a mortgage loan. Yeah, talk to your client about this stuff. She likes arts and crafts to get the things that she wants. Would anyone like to bet whether Clayton told the bank that he owed $200,000 in legal fees to Woodnick? I will bet you a full dinner on me at Taco Madera, excluding alcohol. Clayton did not disclose that debt to the bank. Okay, when okay, the date was October 1st, 2025. Well, the thing is he doesn't owe that bill. It's said in an agreement that your client owes that money. So it's not Clayton's debt, it's Laura's debt. As soon as the judge said Clayton is not in charge of his attorney fees anymore, Laura is. So Clayton can prove, no, this is not true. I don't actually owe these debts. Laura owes this debt. Like, okay. So I guess you're going to say, oh, yep, you're going to say it. Because there is no debt. It's a sham. If I'm right, and to be clear, I'm just speculating about this, that means one of two things. Clayton committed bank fraud when he applied for a mortgage without disclosing a real $200K debt he actually owed. Or two, Woodnick lied to the bankruptcy court by falsely claiming Clayton was harmed by debt, which Woodnick knows is fake due to the side agreement between Clayton and Woodnick. Or three, what I just said. The court said that Clayton doesn't owe this debt, Laura does. So it's not Clayton's debt. But yeah, sure. I don't know where your full-fledged thinking goes. Like, you only partially think. Use your whole brain for once, Gingras. Or who knows, maybe I'm wrong again. Probably. Usually you are. Maybe Clayton did fully disclose the debt to the bank. Maybe his income is so high the bank didn't see an issue with his debt to income ratio. Maybe Clayton has been making monthly payments to Greg Woodnick for the last several years, or maybe not. Your client's supposed to be paying Woodnick. Let's be fair. Let's not speculate about this. Let's get to the truth. 5 hours later. Jesus Christ. What the hell? Yeah, Clayton did say he spent every penny in his savings to buy the house. Exactly. Once discovery opens in the bankruptcy adversary proceeding, I'll shoot a subpoena to Clayton's bank asking for a copy of his loan application. Does that mean that in the adversary proceeding? Okay. If that 200K isn't listed on the application, well, maybe Queen Jennifer will be interested in pursuing that further in the interest of justice, or maybe not. She won't, because she knows your client is the one who owes that debt, not Clayton. Just my opinion. God, he is something else. And then good news, bad news, and here comes the fire. This one was posted on February 28th. I debated reading this, but we'll read it. It's just slamming Judge Mata and thinking that things are going his way in his life. So he says, remember I said I was leaving Arizona? Well, I have some good news and some bad news about this. Obviously, which thing you believe is which is a matter of perspective. So I won't apply any labels. Pick your own. My departure from Arizona is on hold. This is not my choice. I agree, it's not your choice because you have a DUI. He says a couple of superseding events have occurred that pushed my clock back. One has to do with the family member health issue that I won't disclose. It's not me. Hopefully it's not Laura either. Also, I tried my best to leave sooner, but all the prep has taken a lot longer than I expected. I've spent the last few months rushing to get my house cleared out and ready to sell. It's a big house, and it's full of lifetime worth of tools, toys, whatever that is. It also apparently needs a new roof. So that's being done on March 9th. Well, good. Nobody cares if your house is big or small. But I guess that means that Laura won't be staying with you in Arizona. If her parents have to move, if you're not going to be here. But you said you were going to be here a little bit longer, so maybe she will be. That is my speculation, people. That is not fact. I'm speculating she could stay with Gingers if her parents have to move. That and the second news item has slowed me down to the point that leaving before summer is impossible. That means I realistically won't be able to leave until the fall. No one buys, sells houses in Arizona during the summer unless they have a death wish. I'm sure some do, but some move so that they can start school, but okay. Or move so that they can go to a different place, not in Arizona. I don't think the summer is just a shit time fully. But I don't think that's the only reason that you are stuck here. You are stuck here because of your DUI thing right now. You haven't asked to move. You don't have permission to move. News item 2. The bar guy Jim apparently saw the DUI body cam footage and realized that case isn't the slam dunk he thought it was. You were drinking and driving. Whether the body cam footage shows you acting crazy or not, you were still drinking and driving. Undeterred in his quest to throw me back into the fires of Mountain Doom, he's gone back to the bomb-sniffing dog stuff as his next best weapon. Oh, it's another word for knickknacks. Okay. Your body cam footage has nothing to do with it being a slam dunk case. So, like, your blood and your breath test do, and you've admitted to drinking. Said so on February 17, 2026, Jim finally pulled the trigger and filed his formal complaint. It's actually smaller than expected. He dropped some stuff that was in an earlier draft. I made a video about this explaining that Woodnick apparently lied to the bar. But after I posted the video and offered my receipts, Jim Lee realized I was telling the truth and Woodnick was lying, so that claim was dropped. You don't know that that's why that claim was dropped. Maybe it wasn't. There's plenty of bigger deals to deal with than that particular one. The rule gave me 20 days to respond. I did it in 2. My response was so fast, the clerk actually stamped the wrong date on it. LOL. Such a knee slapper, David. You're so funny. Since then, it's not gone well for Jim. That's your opinion. We had a housekeeping hearing last week with the bar judge. The judge said she believed Jim's complaint violated a procedural rule. Because of this, Jim had to go back and submit an amended complaint. Okay. You just had to amend a complaint, amend a filing for Laura. Oh my God, Jim had to amend a complaint. In the meantime, I'm not sitting around crying. Oh no, brother. Anything but. Okay. That's a weird way to say that. Very cringy. Instead, I have taken Jim's gift and run with it. I mentioned this before, but I had the option of responding to the complaint with a motion to dismiss, either a normal 12b6 or an anti-slap. I could have won either way, and it would have made life easier. Okay. I don't know that you would have won, but all right. You think you're going to win everything, so excuse me if I don't take that I was going to win seriously from you. Instead, I seized this golden opportunity and did something else. I immediately started issuing subpoenas. Under the rules, I have the power to subpoena anyone who might have relevant information. And boy, am I pleased to have that power. You're not Superman or anything. Not Spider-Man, the Hulk. You're not even Ant-Man, okay? You're worse than Shazam. The Commission on Judicial Conduct, which has concealed its record on Mata, Epstein style. Mata and Epstein, really? Okay. Got the first one. Okay, whatever. I demanded they hand over every piece of paper they have on Mata, including any written response she submitted to my complaint. Their deadline to comply is March 9th. Oh, good. The day you're getting your roof done. So I guess March 9th is going to be a good day for you in your world. I'm not a jerk by giving them a little time to respond. So little time to respond. The bar rules for discipline cases are almost laughably short. I have like 6 weeks to finish discovery. So every subpoena will have a similarly short compliance deadline. Mata and her dad are next. The subpoena to Mata's dad has been issued, and he should have it today. So he should have gotten that February 28th, apparently. His compliance date is also March 9th. I'm still waiting for the clerk to issue the one to Mata. She'll probably get that Monday. Okay, so she should have gotten it on the 1st, 2 days ago. In addition to asking Mata for documents, I'm going to take her deposition within a few weeks. I know JFC thinks this is impossible. Prepare for disappointment bigger than Hey Rob just got. I Judge Mata can be deposed. People can be deposed. Like, I don't think anybody's shocked that she could possibly be deposed for things. Because I don't know that judicial immunity applies to that. Maybe you don't notice this, but last week Bill Clinton was deposed in front of Congress. Donald Trump was deposed multiple times in the past. A person's status in government does not entitle them to obstruct justice. Nobody said that. Nobody has said that. Any person with information about a case or a claim is obligated to answer questions. Mata will be no exception. She is the key witness, so she will have to answer questions like any other witness. Okay? I don't think you're going to get what you want out of Mata. I have a whole video on how Mata could have legally obtained the information that she said. And there are other ways as well that don't equal what your speculation and your client's speculation is. But go on with your bad self, sir. Lordy. But the fact I can make her sit for a deposition doesn't mean the truth is finally about to drop. Who are you to say if that's the truth or not? You don't know. Honestly, all I'm seeking here is truth, but you have to remember who we are dealing with. You still haven't showed where Mata has lied about anything necessarily. She misstated some things. But he says, Mata has never offered any public response to my allegation in nearly 2 years since I made them. Why not? Because she doesn't have to answer your questions. That's not how any of this works. If you depose her, that's different. If she's a witness on the stand, that's different. But in her role as a judge, while she's a judge on a case, she doesn't have to answer your questions, sir. If she had an innocent explanation, why not share it? Wouldn't you? No, because she doesn't think you're worth it. She just reported it to the authorities. She doesn't want to deal with the likes of you. You're beneath everybody. She clearly has talked to Jim Lee, but he has not yet shared any of that information with me. Per the rules, he'll be required to give me that information next week, but based on past experience dealing with him, I won't hold my breath. Okay, all right. My exception is Mata will plead the my expectation is Mata will plead the Fifth Amendment and refuse to answer most of my questions. If I was her lawyer, that is exactly the advice I'd give her. Thank God you're not her lawyer. And she would have a better one, hopefully. Okay. Here's why. The state court judge have no immunity for federal crimes. A state court judge who commits a federal crime can be charged and convicted and sent to prison just like anyone else. Just ask this lady. The case with Judge Dugan, way different than Mata misspeaking and saying Planned Parenthood was closed. They are so different. In this case, I have expressed my view that Judge Mata may have committed at least 2 federal crimes. First violation, 18 U.S.C. 242, which makes it a crime for a person acting under the color of the law to violate someone's constitutional or federally protected legal rights. The law applies to Judge Mata. Don't take my word for it. Let's hear what Queen Jennifer's boss says. Section 242, Title 18, makes it a crime for a person acting under color of law to willfully deprive a person of a right or privilege protected by the Constitution or laws of the United States. I'm going to tell you that the police officers and the DA's office in the Karen Reed case are the people that violate things under the color of law. Not Judge Mata. Not even close. Acts under color of law include acts not only done by federal, state, or local officials within their lawful authority, but also acts done beyond the bounds of the official's lawful authority if the acts are done while the official is purporting to or pretending to act in performance of his or her official duties. Persons acting under color of law within the meaning of the statute include police officer, prison guards, and other law enforcement officials, as well as judges, care providers in public health facilities, and other who are acting as public officials. Got that? As well as judges. Couldn't be any clearer. State court judge plus federal crime equals federal prison. Yeah, but she didn't do that. She didn't do any of this, and nobody has found any of that to be credible by anything you've had so far. In this case, I believe Judge Mata violated those rules in multiple ways. First, she violated Laura's right to a fair trial before an impartial judge. Yes, I understand the Court of Appeals rejected that argument, but it did so because it claimed I lacked proof to back up that allegation. Well, guess what? Jim just gave me the power to get the proof I needed. And like the bombs Trump just dropped on Iran, oh God, I hope I don't get this video taken down because of that word just now. Because YouTube has said they're not allowing that stuff. I am laser fucking focused on my target. You're still not going to get proof that you need. No matter what power you're given, you're not going to get any proof to prove anything because it's wild speculation and it's not based in fact or reality. Side note, if I get the proof I need, there will probably also be motions filed in the family court asking the new judge to vacate Mata's judgment in favor of Clayton. That motion, if granted, would moot much of Queen Jennifer's work, but that convo's for another day. Well, the thing is it could just get retried. Like they could just represent to a new judge. A new judge could review everything de novo and make a ruling. But in your dreams, this is what you think is going to happen. Second, I believe Judge Mata violated 18 U.S.C. 242 by refusing to enforce the California DVRO. It's funny because the California judge basically gave the same thing that Judge Mata said. They didn't enforce it in California. For the Arizona people, they're not enforcing it in Arizona. Like, it's still not correct. Not only did Mata refuse to enforce the order herself, she actively stopped law enforcement from enforcing the law by telling them not to do what the law said they were required to do. Well, the police officers also said they didn't believe anything was happening. Mata's conduct willfully deprived Laura of the right she had under the laws of the United States, the right granted by both full faith and credit clause under VAWA to have intense interstate DVROs enforced in all 50 states. This could also arguably constitute other federal crimes like obstruction of justice, obstruction of a court order, and obstruction for criminal investigation. No, it won't, but okay. Also believe Judge Mata committed a federal crime by retaliating against me for reporting this stuff to law enforcement. That's a separate crime under thing. She reported you to law enforcement? Or she reported this stuff to the courts, the bar? Whoever knowingly, with intent to retaliate, takes any action harmful to any person, including interference with the lawful employment or livelihood of any person, for providing to a law enforcement officer any truthful information relating to the commission or possible commission of any federal offense, shall be fined under this title or imprisoned not more than 10 years or both. Yeah, I don't think that's talking about what you think it's talking about. Now, let's be clear. Is Mata about to trade her black robe for 10 years in an orange jumpsuit? Of course not. Federal charges can only be filed by the U.S. Department of Justice. And at the moment, the DOJ is firmly MAGA control. As we know, MAGA doesn't prosecute MAGA. I don't know Judge Mata's personal politics, but she was appointed by a MAGA governor. So draw your own conclusions. You don't need to know what the judge's political views are. I don't see why that's relevant at all. But here's the thing. Donald Trump can't run for a third term. He will probably suffer death by cholesterol long before then. And you by drinking alcohol. What the hell? Why does everything have to be so political? I cannot stand people who make politics their entire personality. Have more to your life than politics. I don't care what side you're on. But this is your whole personality. If the next POTUS is a Democrat, looking at you, Gavin, all the MAGA-infested DOJ folks will be gone soon, long before the statute of limitations expires on the crimes I believe Mata committed. If we have a new Democratic administration in 2028, Judge Mata could easily face prosecution for any federal crime she committed. I don't think it's going to matter who's in office. It's not happening, Gingras. That may sound crazy. Yeah, it does. In this sad Trumpian moment we're having, you're the only one having this moment. But it's not crazy. It literally just happened to a judge in Wisconsin, and it could happen here. No. Like I said, Judge Dugan and Judge Mata, not anywhere on the same wavelength. Y'all can go look up what Judge Dugan did. For that reason, I'm guessing the only question Mata will answer is her name. When Trump was deposed a few years ago, he pled the fifth hundreds of times. I won't make her waste that much time. Okay. Assuming Mata pleads the fifth, as a practical matter, that will end that part of the case. The state bears the burden of proving I said something false about Mata, and that I knew it was false at the time. But if Mata invokes the fifth, she won't be allowed to testify at the hearing. Without her testimony, the bar won't have any witnesses available to meet their burden for the part of that case. They could possibly show the hearing itself with somebody. But who knows? Maybe I'm wrong. Certainly wouldn't be the first time I was wrong. Not going to be the last time you're wrong either. Maybe Mata has non-incriminating answers to all these concerns. I'd love to hear them. I've been waiting patiently for years, and so have you. No, we have not been waiting patiently for Judge Mata to explain the screw-up. We don't care. We understand. Anyway, I'm going to be pretty busy ferreting out the truth over the next few weeks, so watch this space for updates. The truth always wants out, and we've all waited far too long for this part. Oh, and before you ask, Jim Lee asked the bar judge to seal the complaint. She granted that request, so I can't share it even if I wanted to. Sorry. Which a lot of times they do seal. Sometimes they unseal it when it's over, but sometimes they don't. For now, there's no protective order prohibiting me from sharing other information like evidence obtained via subpoena. So when I finally get those CJC records, I'll probably share them. And then he addresses Bianca Bono directly. You still with us? Oh, shit. Apparently not. Was Bianca Bono on their side at one point? I don't know if is he trying to say that Bianca is reporting on this case or originally was reporting on this case because she was for Laura Owens? Like, I've only known Bianca to present facts, like a real journalist that you usually like, but oh, that's right. She did move and now she's not reporting on this case. Yeah, but I don't think Bianca was on your side, Gingras. But he's making this comment to make it seem like Bianca was actually on their side, not ours. I don't read the tea leaves the same way, but okay. He says, get your popcorn ready. Sounds like the summer is going to be a real scorcher. Yeah, I'm sure it is in more ways than one. P.S. If this case isn't tossed out early and if it ends up going to trial, my star witness will be Woodnick. But I'll talk more about that later. And then he put Phoenix. Okay. Yeah, it's been hot down here in Texas as well. Not 92 degrees, but hot. Yeah, Judge Dugan found guilty of felony obstruction in a federal trial. Yeah. It's just like his own delusions. It's just not. So Dugan was found guilty of a misdemeanor concealing a person from federal immigration law enforcement. And so they said that interfering with federal agents as they tried to make an immigration arrest outside her courtroom and with the help their target to evade arrest. And they're not allowed to do it in a courtroom, I don't think. I think they can do it when they're out. But judges shouldn't be helping defendants evade arrest. Like somebody that wasn't here legally. But like it's not anything close to making a misstatement or saying that some information came from this witness and it came for somebody else. Echoes, if you don't quit bringing up dessert. No, Texas brought up dessert to Echoes. Echoes owes me cake. I'm saying it right here. Echoes owes me cake. And I don't have any cookies. Nobody give me any cookies. I do have some Reese's peanut butter eggs. The egg-shaped Reese's things. Yes, Echoes owes me cake. If we ever see each other. Which I don't know where exactly fully he lives, but it's probably not too far from me. Like, not like a crazy amount of far. It might be, but um anywho, that is what is happening here. In the IAH, Jingers's stupid blogs and all of that. And I am going to go get my hair cut off because it's so long. It's just so long. And I need it fixed to make me feel better. Oh, that sounds so good. So good. All right, y'all are making me hungry. Y'all go eat dinner and all that. I will be putting out a video, possibly it might come out later today or late tonight, or early tomorrow on Clayton's complaint that Laura submitted to the real estate people. So come back for the next video to see the haircut. But have a good night. Bye.